Okay, so we'll go ahead and get started. It looks like there's still some people joining in, but I want to welcome everyone to tonight's program, 10 Things to Look For in a Job Contract. And I would like to introduce, sorry about that, our speaker. And our main speaker is Jeffrey Myers, and he graduated from University of Pennsylvania Law School. He's been practicing law. He practiced for about 30 years at a firm in Philadelphia. He served as the outside counsel to LECOM, and he became their associate general counsel in 2010. We also have Jennifer Quist, who is a fourth-year student at LECOM and chair of our council and membership. I am Danielle Bauer. I'm ASDA's Director of Membership and Marketing, and Jennifer and I will be serving as tonight's facilitators. So you will be able to ask questions. You can go ahead and type them in as the presentation's going on, but we will take questions at the end. So if you look over in the control panel, you'll see a little chat area, and that's where you can go ahead and type your question, and we will try our best to get to all of those questions. All right, so with that, I would like to introduce Mr. Jeffrey Myers, and I am going to turn the presentation over to you.
Okay, can we see my slides?
Not yet. I think you have to hit, yep, there we go. We're good.
All right.
Yep.
Good evening, everyone. I'm Jeff Myers. Forgive my address. I realized I started working today at 4 a.m. and I went home at a kind of a normal hour. Then I realized I couldn't hook up with you guys from home, so I had to race back in to deliver this, what will hopefully be a scintillating seminar on contracts. As healthcare professionals, you're going to be inundated with contracts. You're going to have to deal with leases, vendor agreements, collaborative practice agreements, but personally, maybe immediately, and maybe most importantly, employment agreements. Before we get into the top 10 things, I want to tell you 3 rules, and don't forget these 3 rules. Number 1, read every word. Number 2, always assess your relative bargaining power. If you have bargaining power, and if you're very young and inexperienced, you do not have bargaining power. But once you reach the point where you do have bargaining power, get something for everything you give. Third point, very important. I told this to every client over 35 years of practice. As you're taking the pen into your hand to sign the contract, you need to ask yourself one question. Do I trust the other side? If the answer is not a clear yes, drop the pen and leave the room promptly. I am not joking. All right. You want it all? You're not going to get it all up front. You're going to have to wait. You're just going to have to wait. You cannot be delusional. Like I said, you have to take a realistic view of your own bargaining power. And, you know, with every document, as I said, read every word. You start out at the beginning. At the top, you're going to have the title of the agreement, and it's typically going to say this employment agreement or this contract or something. As you scroll down, just realize another important rule. It's called the parole evidence rule. Anything you want in that document has got to be within the document itself. If not, you're not going to get it into court if you're trying to prove a breach of contract down the road. So as you start reading, start clicking through your head everything you want in that contract and make sure it is in black and white. The next question is, well, how far am I going to go with these people? How far am I going to go? Is this a simple employment agreement? That's fine. And then just talk about employment. Is it also a buy-in agreement? Is it a stock option agreement? You'll see something in every contract, usually towards the back, called the integration clause or the whole agreement clause or the prior agreement clause. That clause, however named, will tell you all the elements that are within the parole evidence rule. So if the contract says this agreement and solely this agreement constitutes the entire agreement between the parties on the subject matter hereof, that's what you got. Next, you want to, as an employee, as a dentist, you want to clearly identify who you're working for. Is it a company? What company is it? Is it a subsidiary? Who's on the hook to pay your salary? You also might be curious about what the employer's home state is, because sometimes the state in which the employer is domiciled, where its principal place of business is, and or it's incorporationalized, will indicate what law applies. Contract law is a creature of state law. We have a federal system of government, we have federal laws, we have state laws. When it comes to contracts, you have to focus on state laws, and every state's law is different. For example, in many states, you don't even have to have a writing to have an employment agreement. Every state has something called a statute of frauds, Frauds, and if the statute of frauds says employment agreements don't have to be in writing, you don't have to have a writing. Of course, I strongly recommend that you do have a writing. So after the prefatory paragraph, where basically the parties are going to be identified, you might see the word recitals and then a variety of whereas clauses. Now, I know in real life no one ever uses the word whereas, but you will see them in employment agreements. A lot of times they set the parameters. They tell you what the other side's looking for, and they should accurately reflect what you're looking for. It's a statement of intent. It might tell you certain prerequisites to entering into the agreement, whereas dentist is licensed in the state of flux and has privileges in this clinic or that clinic. You always want to make sure what is there is accurate, that you can comply with it, and there's a precise and clear statement of the intent of both parties. So this will typically take you down to maybe the middle of the first page. Then you get into the nature of the relationship. Is it an employment agreement or an independent? What?
I'm so sorry to interrupt you, but your slides aren't advancing on our screen. Are they advancing on yours?
Yeah. Well, I just went to the second slide. Or I just went to, how about now? Can you see the advance now?
No,
Well,
we've still got you on slide 1. I didn't want to interrupt, but I double-checked your PowerPoint, and I was like, nope, I'm pretty sure.
Danielle?
Make sure you don't have, I think where it says show my screen, there's a pause button, and it will pause on a slide. Just make sure that's not selected.
Who are you talking to, me or the audience?
Yeah, I'm talking to you.
All right, how are we looking now? Do we see nature of the relationship at the top of this one? All right, let's, sorry.
We see 10 key terms.
What?
Not in presenter mode.
Are we good?
We're on 10 key terms.
Nature of relationship.
Yep,
okay.
Yep, we're good.
Okay.
We're good.
So everything, okay, let me go back just to show you the slide I was referring to. First, we have a couple of memes. Of course, you have to have memes in any PowerPoint. You can't have a PowerPoint without memes, right? Then you have, you shouldn't. Then you have introduction, and now we're into nature of the relationship. You have to define the nature of the relationship. Now, some employers might seek to sign you up as an independent contractor. Is that a good idea or a bad idea? Well, you don't pay taxes. Problem is, you could be engaging in felony tax fraud. If the person for whom you are performing services controls what you do, and you are economically dependent upon them, it is not legitimate for you to be deemed to be or called an independent contractor. You are an employee. Next, what kind of an employee are you? Full-time, part-time, locum tenens, or, as needed? Is there any equity position to be given, presently or in the future? Now, if in addition to the employment you're given an equity position, you want to make sure you know how much equity you're given, your vesting schedule, when you actually have a right to the stock, the strike price or the exercise price, and the anti-dilution provision. It's great to say, you'll get stock for 10% of the practice, but every time they add a new dentist, that gets diluted. That's not so favorable for you. And other terms of the stock agreement. Typically, if you have a piece of the action, if you have an equity position, there's going to be a second agreement in play, and that will have to be mentioned in the integration or whole agreement clause. Exclusive, or do you have to perform your services exclusively for one entity? Typically, yes. Outside activities, to what extent? Can you engage in volunteer work, charitable work, academic work? If any of that's of interest to you, make sure that's clear. Are you subject to any type of handbook or manual. Now, if you're going into corporate dentistry, and I have 3 contracts that can be distributed to you, and we might take a gander at depending on our time. We have a straight practice contract. Typically, there might not be a reference to a handbook there. But if you're going into corporate dentistry, there is going to be a reference to a corporate manual, which is going to be incorporated by reference. So you need to take a look at that before you sign. Finally, up front, another key indicia is intellectual property. Everyone on this call, all 86 of you, are very bright people. You're capable of coming up with new and innovative ways to provide dentistry or to manage a dental practice. If you come up with an idea, who does it belong to? Do you have a right to it, or does the employer have a right to it? If your intellectual property is deemed or called a work for hire, you have just given it away. So make sure that any intellectual property rights are properly distributed between you and the employer, especially something that you're on the brink of finalizing. You don't want to just give that away to the employer, because there is a place where you have bargaining power. I'm going to switch slides now. Scream if I didn't do it right. All right, I don't hear anyone screaming. Next, we have term. 2 options. Set term or at will. At will means there is no real term. You keep going as long as you both can bear the sight of each other. Confirm your start date. Is any time guaranteed? Now, a lot of times, people will come to me or call me up, clients will come in and say, hey, I just got an offer for a 5-year deal. I said, really? It's a 5-year deal? Oh, absolutely, it's a 5-year deal. And I always say, well, go to the termination provision, because the termination provision is really what sets the term. It might say 5 years, but if you can be terminated on 60 days notice without cause, you have a 60-day contract. You do not have a 5-year contract. Also, ask yourself what happens if the corporation or practice is sold. Where does your employment go? It is to the benefit of the employer to have your contract assignable, i.e. they can just sell it and move you along to a new entity. The question you have to ask yourself is, do you want to go along with that? Because juxtaposed with an assignability provision, you might want to have a change in control provision, which allows you to opt out if your employer sells its operations. So always be looking ahead and make sure you know exactly how much time you have in the bank. Next, your duties. You need a title. You need to know what's expected of you. Make no assumptions. Always ask, is there a job description? Where will you be practicing? What's your title? What are you doing? Where are you doing it? I had one dentist approach me with what looked like a pretty good contract, but the contract gave the practice the right to send a dentist to any one of 6 different locations with some significant travel involved. So always ask yourself not only the what, but where. What's your schedule? For young dentists, they're expecting you to put in a pretty full week. Anywhere from at least 36 to 40, 42 hours. And you're exempt from overtime, so it just doesn't matter. What level of authority do you have? Typically, it's going to be none. But ask, clarify, see what kind of supervisory responsibility you have over technicians or hygienists. That's important, because you could be on the hook if you're working with a tech and they make mistakes or they exceed their practice boundaries. You could be subject to discipline. So make sure you check out your level of authority and your supervisory responsibility. What kind of management do you have in the company? Do you have any sway or hold or decision-making power over non-professionals in the practice? These are all things you want to nail down. Going to the next slide, number 5, compensation. Does anyone want to work for free? Anybody? No, didn't think so. What are you going to get? Well, if you're real lucky, if you have like a third arm or something, or you have a book of patients, I mean, what makes a dentist valuable? What makes a dentist valuable is skill and patience. If you are lucky enough to have extraordinary skill or patience, you might get a signing bonus. Don't count on it. That's pretty much a laugh for most of you. Now, what you're going to see is either a salary or a draw against a productivity payment. You're going to get a straight salary, maybe forever, for the whole term of the agreement, or for a certain part of the agreement, after which you basically get what you kill. You get a percentage of that which you produce. Or you get a draw against the productivity payment, which is reconciled on, say, a monthly or quarterly basis. Bonuses are great. Make sure you understand the formula. I've seen some pretty complicated formulas. Always ask for an example. Sometimes they give them, sometimes they don't. Ask for one. What about raises? And don't assume you can only go up. See if there's a possibility that you might go down. What's the range of increases? What's the range of reductions? What's the timing? Sometimes this is going away, but sometimes we see provisions called cost of living adjustments. They're tied into consumer price indexes. If you do have a COLA, you would have tied into the biggest city around, because they have larger urban areas, have more significant increases in consumer price indexes, and that would lead to you getting an increase in compensation. What, if anything, do you have to pay? Do you have to put a deposit down to buy into stock? Do you have to purchase supplies? What are your financial obligations? Do a balance sheet. Don't be in a hurry, because sometimes the practice may ask that you pay for certain things. Now, when I was young and practicing, when I started practicing, it was all about salary. All about salary. Now, people in this generation care a little bit more about benefits and time off. So we want to look, and there's a whole laundry list, a whole menu of possible benefit options you want to look at. What type of benefit plans does the employer offer? Now, I am not here to recommend corporate dentistry, but the reality is corporate dentistry is typically going to have certain benefit plans in place that will give you more than an independent practice. If you have a practice that has benefit plans, you either have set plans or a cafeteria arrangement. Cafeteria arrangement is where the employer says, I'll contribute, or I'll give you an allowance of $500 a month, and you can use that to purchase whatever benefits I have available. Whatever shortfall is out of your pocket. There are various kinds of insurance, and of course insurance are important to us: health, dental, vision, disability, life. Always ask yourself, who's paying? Is there dependent coverage? What's my maximum yearly out-of-pocket? That's going to be a combination of copays, deductibles, and your contribution. Malpractice is a key element. In smaller practices, you're going to pay. In corporate practices, they're going to pay. There are two basic types of malpractice insurance, ladies and gentlemen. One is called occurrence. The other is called claims made. An occurrence policy is better for you. It's also more expensive. So if an employer requires you to get an occurrence policy, you want to say, hey, will you settle for claims made, because it's going to be a lot cheaper. Why is occurrence more expensive? Occurrence is more expensive because it covers anything bad that happens during the term of the policy, regardless of when a claim is filed. So if someone files a claim a year and a half later for something that happens today, you get the benefit of the good policy you have in place today. Claims made policies are much cheaper. They only cover claims that are made regardless of the underlying conduct that are made during the term of the contract. Now, if, say, you have a claims made policy and you leave the employer, that policy is going to expire by its terms. They typically expire upon termination. You are going to need a tail policy. You're going to have to go out and purchase a tail policy, and sometimes employers will require you to buy a tail policy for after filed claims. Believe me, it's in your interest to have a tail policy. If you are assigned a management position in a practice, you want to see what kind of D&O protection they have. That's directors and officers insurance. That's only if you have a management position. They are the various insurances that we talk about. Now, in addition to that, what kind of pension vehicle do we have? Typically, in the old days, the predominant pension vehicle was a defined benefit plan. Contributions would be made on your behalf, and at a certain age or after a certain number of years of service, you would get a set benefit. That type of vehicle is kind of going away. Typically what we have now are defined contribution or 401k plans. In the public sector, you would have 403b plans. You get to contribute up to a certain amount of your compensation, and the value of the plan, the money vests immediately. Vesting is immediate, which is good for you. And then how much the value of your plan is typically based on the quality of your investment options and choices. Other things that are of value to you is who pays for the supplies and equipment. You all know that there's going to be a lot of that in dental practice. Some practices pay, some expect you to pay. Professional expenses, you're going to want to be active in the community. You're going to want to be active in your profession. Who's going to pay for memberships, journals, and licensure? You're going to be licensed in at least one state, and it's a couple $100 a year, but still, it's an expense. Continuing education is more of an expense. And here, you see, I've seen at all levels, corporate, private, and even rural and small town dentistry, some allowance for continuing education. Remember, check your state for what kind of continuing professional education you're subject to. You have to check the reporting period, typically 2 years, the number of hours, whether you have any particular subjects you have to take, and whether any of the continuing professional education must be live. Check your state law. Another benefit which you want to look for is indemnification. Indemnification, in the old days, we would call an insurance policy an indemnity policy. Indemnification means, or is indicative of, who pays damages, who pays losses. You always want to be indemnified. You do not want to be an indemnifier. You want someone paying for damages in any type of claim you're involved in. You don't want to be the one paying. There are some, and it goes both ways in dentistry, and it's really a matter of bargaining power. But given the fact that if you're indemnifying your employer, the amounts are really hard to predict. You're going to try to get that out of the contract, or you're going to need additional insurance to cover the contingency of you being called to indemnify a loss. Next, we have termination. There are a variety of ways a contract is terminated. If you die, your contract terminates. No one can be expected to pay a dead person. If you become disabled for an extended period of time, your contract will terminate. Then contracts can terminate for cause or without cause, or you can quit. Now, always check the for cause reasons. You want to limit them, and you want to make sure they're clearly and specifically defined. You want those for cause reasons to be as narrow as possible. The other thing is, okay, the employer has a right for cause to terminate you for failing to complete certain work in a certain time frame. Do you have the opportunity to cure? Always check for that. Ask for that. If perchance you make a mistake, if there's some negative outcome, do you have a chance to fix it? Is the employer's breach addressed? The answer, obviously you want that. You want to have the right to terminate the agreement for cause. What about not for cause? The key there is how much notice you get. And the not for cause notice, ladies and gentlemen, is the real term of your contract. That's how much time you really have. How much notice are you supposed to give if you decide to quit? Well, there are two ways you quit. You either quit for no reason or you quit for a good reason. Quitting for a good reason means you've basically been forced out. And that is the functional equivalent of being terminated not for cause. Now, if the employer imposes upon you an obligation to give notice, in most states, the common law, judge-made law, will read a correlative benefit onto the employer. So if you're expected to give 60 days notice, the employer in many states is expected to give or pay in lieu of 60 days notice. I alluded to disability earlier. Make sure you understand how it's defined and handled for larger practices, for corporate practices. You may be covered by the Americans with Disabilities Act. You may be covered by state EEO law. You may even be covered by the Family and Medical Leave Act if you work for a practice for a year or more. These are federal laws that cover larger practices, and the Family and Medical Leave Act gives you up to 12 weeks off a year. If you become seriously ill, the employer can't touch you during that period if they and you are covered. And again, you have to be there for a year to be covered, and they have to have more than 50 employees. In smaller situations, you might be covered under state anti-discrimination provisions, and the employer cannot discriminate against you and might have an obligation to reasonably accommodate you if the reasonable accommodation can bring you back to a level of full qualification. With termination, sometimes we look to see if there's severance pay. Typically, there is severance pay if you are terminated without notice or without cause, or if you're forced to leave. If you quit for a good reason, you might be entitled to severance pay. So know if there is a severance pay policy and know what the eligibility conditions there are in connection with getting benefits under that policy. Next, we have covenants. I will tell you, especially those of you who are young on the phone, if there's one thing you can knock out of an employment agreement, your number one thing to knock out is a covenant. What is a covenant? A covenant is a restriction on otherwise lawful conduct that may be contemporaneous with your employment or may occur or arise after your employment terminates. Covenants are to be avoided. There are at least 5 different types of covenants, and I list them there. Non-competition, typically that says you cannot set up a dental practice that competes with your existing practice within a certain radius, typically anywhere from 5 to 20 miles. Non-solicitation. Now, judges hate those. Judges hate those. Why? Because they go against the basic free enterprise system, but they can be enforced. They can be enforced, except, of course, in the People's Republic of California and a couple of other states. Colorado does not allow them anymore. Always check your state law. I mean, you know, if someone gives you a non-competition covenant in California, say, fine, I'll take it. They'll never enforce it. Non-solicitation agreement, even if you agree to it, it won't be enforced in California. Non-solicitation agreements are more prevalent. They're more specific. They could actually be more damaging to you because they will be enforced. These types of agreements say that for some period you cannot solicit or seek to perform dentistry for existing patients or individuals who have been patients or prospects within the last year of the practice. You might also have a non-solicitation provision extending to vendors so that you cannot purchase or solicit vendors to sell to you. Anti-piracy means you can't take other members of the practice with you. IP is intellectual property. There might be some limit, and again, you got to go back to the beginning. How did you set up the IP protocols? Who owns the IP, and who takes it with them? Confidentiality. Understand that with or without a covenant, you're going to be under an obligation to maintain the confidentiality of the proprietary information of the practice for so long as it is indeed proprietary. When's something proprietary? Something's proprietary when it is developed at some expense by a specific entity. It has value to that entity and would not be disclosed to the general public absent wrongful conduct. So just be aware of what they consider to be proprietary. Understand the duration of the confidentiality provision. Confidentiality provisions that typically are not enforceable once the information sought to be protected is in the public realm, becomes part of general knowledge. Always check your time limits and geographic scope. The good news for you folks is, well, if you're an owner of a practice, this is bad news. Restrictive covenants are only enforced to the minimum time and geographic scope necessary to protect important interests of the practice. A couple other things. When you leave, what access do you have to the records? Of course, the practice continues to own the records. Ownership and transfer provisions of records is also a creature of state law. I want all of you, as part of this exercise, at some point, to go on your state Board of Dentistry website and see what provisions there are in the regulations for dentistry separate from practice. You might want to have a provision or seek a provision for a positive or at least a neutral reference. There could be a provision for ADR, alternate dispute resolution. That calls for a streamlined, cheaper, more efficient means of litigating any disputes over the propriety of the termination of a covenant or a contract, ADR. It's probably more in the practices, it's probably more to the advantage of the practice, but you too will save money. Finally, indemnification. Now here's the positive thing. If you're leaving, you want to see that the practice is going to indemnify you, basically give you a clear rear view mirror. You don't want to have any ongoing indemnification obligations to the practice. They might also seek to have you cooperate for any cases that you worked on, cooperate in any investigations, cooperate in any audits, say Medicare or Medicaid audits, if you're dealing with those kind of patients. Don't be afraid to ask for compensation for cooperation. It's legitimate, it's normal, it's natural, it's to be expected. Future purchase. Now, we talked about maybe getting stock up front. And we got to know what our vesting schedule is, what our strike price is, how much dilution we may suffer. Separate and apart from just getting a piece of the action is they might go the whole route and say, well, you know, we want to envision, we want to take you on, and this you might see in a small town agreement more than a standard commercial practice agreement. Certainly you're not going to see this in a corporate agreement. There might be a provision for you just taking over the whole shooting match at some point in the future. Check the prerequisites. I mean, are you going to have a certain time in the practice, productivity? Some of you might not be interested in this at all. But here you have a handy-dandy checklist of things you want to go down and audit in terms of judging the value of this type of provision and whether you're interested in it. You want to think of dilution here as you do with stock. How many offers can be made? Who has offers out there? How many people might it be competing with? Is it just me? Obviously, you want to be the only one who has a future purchase option. You don't want to be competing against all your colleagues. That could become very problematic. What will be included? When you purchase? Will it include the goodwill? How much do you pay? When do you pay? What about the existing owners? Okay, so you have a right to buy a practice, right? You have a right to buy a practice. What are the existing owners going to do? Are they going to stay on? Typically, I will tell you, you don't want that. You want to have them, you want to usher them out the door and have them with restrictive covenants. Out the door with restrictive covenants. Why do you want them to have a restrictive covenant? I told you, you don't want a restrictive covenant. What about fairness here? The hell with fairness. You're paying a lot of money. You don't want them setting up shop across the street from you and competing with you. So get rid of them, get a restrictive covenant. What you want is a term sheet up front, lay it out, summarize it for you so you can make a rational decision. Finally, in any contract situation, we have what is known as boilerplate. And, you know, some people overlook boilerplate or depreciate boilerplate. Boilerplate is very important, ladies and gentlemen. Boilerplate is very important. Number one, I told you, contract law is a creature of state law. So, what state law applies? It could be very different. The law, for example, in Georgia and Florida, I sit in Florida right now, is very different when it comes to contracts. Integration we talk about, We talked about know the full extent of the deal. Does it include stock option? Does it include purchase option? Does it include a handbook? Know the full extent of the deal. Know what you're subject to. Notices tell you how the parties communicate officially. Loser pays is a kind of a scary provision that says that if one party challenges the contract and loses, they have to pay all the attorney's fees. Amendments, that goes without saying. You have to have a means for amending the contract. Savings and severability. Savings and severability are very important. If part of the contract becomes illegal due to a new legislative enactment or due to a court decision in your jurisdiction, you want an assurance that as much of the contract survives as possible. Related to that is a blue pencil provision, which says that if any of the contract is found to be overreaching or invalid, a judge, upon reviewing the contract, can, of his or her own motion, reform the contract to make it legal. Finally, the assignment clause. The assignment clause means the contract is basically up for sale. It can be sold to another party. As an employee, that's not to your benefit. That's not to your benefit because remember what I said. The last question you ask yourself before you sign is, can I trust these people? If it could be assigned, if the contract could be assigned to someone you don't know, well, you can't trust them. So that puts you in an insecure position. I want to switch now. And I want to show you a contract. And I have some PowerPoints which I'll hide from you simply because that's the way we do it. Can we see this contract now? Danielle, can you see the contract?
Yep. Yes, we can see it.
All right. Now, this is a typical, when I was teaching my class, and Jennifer included, I wanted to find them a very typical developed practice agreement. This is out of Southlake, Texas, a suburb of Dallas. It's right off the internet. It's real. I mean, I've negotiated enough contracts to know a real contract when I see one. And for many of you, this is the kind of agreement you're going to see. And you see it starts with the recitals, DDS LLC. LLC stands for Limited Liability Corporation. When you're going to set up your own corporate form, you have to decide what kind of corporate vehicle you have. Many healthcare professionals opt for the LLC or LLP. But it depends on the state. Florida just totally revised their LLC law, and it's a little crazy, but still, you might want to go with that. I just want to highlight some things in this agreement. Who are the parties? Now, in this agreement, you kind of have a third party, and it's a little tricky. They have an LLC, which is going to employ you, but you have another party, which is a management company, which is going to manage the physical plant of the practice. So DDS LLC, and then you have DDS LLC Management. So a couple of different entities involved there. That's not to your interest. Things that are expected of you in this type of agreement, you have to show licensure, mutuality of intent, and you're acknowledging that the consideration is sufficient for your purposes. How long is the term here? The term says 24 months, but I don't know if I can do this. But if you go down, and I hope I can get back, I don't know how I'm going to get back. If you go down to termination, actually you'll see that this is a much shorter agreement. This is a much shorter agreement. Damn it. How can I reduce this? How can I reduce the control panel? I need to reduce the control panel.
There is, I think the little bar, like that you minimize documents, will also minimize the control panel. Or there should be a little red arrow you can click that will minimize it.
Are you just trying to zoom out, Mr.
Okay,
Meyer?
that's fine. I got it. All right. let's go back to the top here. Let's go back to the top here. We have a couple of different parties. We have the scope, we have the purpose, we have the duties. Now, let's see, let's go to the termination provision, and I'll show you why you have to look in two places. I'll show you why you have to look in two places. There you have covenants. We don't like covenants, of course. Under termination, A, 60 days. 60 days. This is really a 60-day contract. It's not a 24-month contract, ladies and gentlemen. Always look in both term and termination to determine how long your contract is. Always look in both places. Every word has a meaning. Scope and purpose. And here, what they're doing with the scope and purpose is they are setting up a predicate. They are setting up a justification for their restrictive covenants, which will make it harder for you to dissolve. We have fees, we have record-keeping responsibilities, we have compensation and benefits. See, there are quite a few duties there that you're expected to carry out, and make sure you know where you're going to be carrying out. Now, remember I told you can get a straight salary or a draw against what you earn. Here, we have a pretty generous percentage. I have seen recently percentages anywhere from 25 to 36%, but it begs the question: 25 or 36% of what? It's what you produce. So you always have to do your due diligence to see how active is this practice, how much are you going to be exposed to, how much can you realistically perform, what kind of fees can you generate, because at the end of the day, you're going to be earning 32%. You're going to get a daily minimum and a yearly maximum. Now, here's where they get you a little. Supplies and equipment. They're going to give you a setup investment amount. What is wrong with the setup investment amount here? Because it's going to go against a lot of things. What's wrong with the setup investment amount here? It's not stated. It's not stated. So in other words, it's whatever they want it to be. You need to fill in that blank. You cannot tolerate that sort of thing. This agreement basically has you're going to earn a percent of what you kill, a percent of what you produce. You are going to get an allowance for supplies and equipment, and you are getting nothing else out of this agreement. In fact, you do get some liability insurance. But look at those words. Remember, you never want to be the indemnifier. Associates shall indemnify and hold harmless. Not a good provision for you. Not a good provision for you. So they're really not giving you a lot here. There's basically no benefits. If it's a very successful practice with very skilled and efficient dentists that are going to give you a fair shot at the work, then maybe 32% is going to be something you can live with. But all of the other costs in terms of insurance, association fees, licensing fees, you're going to pay. You're going to pay. You even, this is where I really hate this one. Look, you're bearing the cost of, even if your own family comes in, you got to bear the cost. No freebies here. Covenants, there are a variety of covenants. They're saying, and again, the prefatory language is setting up a justification for these covenants. What kind of covenants do we have? Non-disclosure and confidentiality. Well, that's not so bad because you have that at common law anyway. That only exists as long as the information is actually outside of the public realm. Non-competition is for 2 years. That is a long time, ladies and gentlemen. Think how well you can maintain a relationship with someone who you don't talk to for 2 years. It's gone. So 2 years is quite a lot. It's also 20 miles. How many people drive 20 miles to get to their dentist? I don't. 20 miles is a long way. I mean, my dentist is probably about 15 miles from my house and 5 miles from my place of work. And of course, I always go to him right after work. You also have non-interference, which is like a non-solicitation provision. You have another non-solicitation provision. You have an anti-bad-mouthing provision in 4. So there are a lot of restrictions. This is loaded up with restrictions. It's loaded up with expenses, but young dentists might be able to make money. 32% is above average in terms of how much you might secure in an initial contract. Enforcement, this is basically telling them if you go to court, you're screwed. Patient records, you can buy patient records back then if the patient asks for them, which is not that bad of a thing. There's also a reference to state practice law, and again, always be attuned to your state practice law in terms of mandates on the practice and any rights that you may have. Termination we looked at previously. It's basically a 60-day contract. Permanent disability, what does it mean? Again, you need to see that policy. What's the policy? How does the policy define permanent disability? There's also a laundry list of things which constitute for cause. Make sure you get, well, actually 4, but you want these to be as specific and clearly defined as possible. So this is what a real agreement looks like. Your boilerplate, your notices, how you communicate with each other, your applicable law. It's the law of Texas. Here we have a binding provision. It's binding on representatives. Severability provision says that the contract survives. The contract in whole survives even if particular parts are deemed to be invalid by legislation or corporate decision. Prior agreements superseded. This is your integration clause. Attorney's fees, you don't like that because you never want to pay the other guy's freight. And the rest is just basically technical provisions. Here you have a possible purchase agreement with a formula. You always want to reserve to yourself the right to have the practice appraised by an independent party prior to entering into the final agreement for sale. That is a typical practice agreement. Let me show you what a corporate deal looks like. This is a little more complicated, and it's not really to your advantage, to be honest with you. I've redacted this because I didn't want to disclose the name of the person who got it to me. It's in Florida. You have a cover sheet. Now, and when you're dealing with insurance policies, a lot of times you have what's called a declarations page, which summarizes all the key and essential terms of that contract. Here you basically have an employment declaration page, which summarizes the key terms of the agreement. It says it's for 1 year. It tells you when it's going to start. Here we have a 30% provision, but again, 30% of what? Here you're going to see that this corporation is involved in a lot of managed care operations. That's not going to be a high yield type of practice. You might end up making less. Your annualized draw is $100,000, so you're going to be guaranteed a salary for like 90 days, and then you're going to go into a draw arrangement where you get paid against what you produce through your own efforts. Time off, 10 days in a year, enjoy it. Final notice period, 60 days. This is a 60-day contract. It's nice of them to put it right up front, but it's not a long agreement. So you might be able to make some money, You need to do due diligence. You might want to contact someone in the practice to see, how much is there really. Here you see the employment, your duties, compensation, and you have various schedules attached to the agreement. Now, this is what should be a red flag for you. Over here, you see, they recognize that some of the work is fee-for-service, which, of course, is best. You always want to have a fee-for-service clientele with private insurance is the best. But they also have a lot of managed care. And you're going to be reporting over here on the right side to a vice president of operations you might see twice a year. So that might give you some cause for concern or discomfort. The good news, if you're dealing with a big corporation, they're going to have the bargaining power to negotiate insurance policies that cover all their employees. They might be good, they might not be good. Key question again is, what is my yearly out-of-pocket? For pension, what are you contributing? I know what I can contribute. What are you contributing? So it's, you're dealing with a big company. You're a small cog in a big wheel. Now, if you want security, if you want infrastructure, if you want a basic benefit package, if you have no other options, maybe corporate dentistry is for you. I would not typically see it as my first choice. I went with a firm which at the time was a moderate to large size firm, which grew into a mega firm. But by that time, I was one of the senior guys, so it didn't matter. Here you have the termination provisions, death, resignation, if you lose your license, et cetera, you have a whole variety of termination provisions. 60 days disability. There's not a lot of security in this agreement, and you do have covenants. So this is what I just wanted you to see, what a corporate agreement looks like. Now, small town agreements, they're all over the place. And if you go into a small town, you might have a little more bargaining power because, an older dentist might be looking to take on an apprentice, might be willing to cut you some types of deals. And what I have seen from a couple of LECOM graduates who have gone into small towns in the South, these are cut and pasted documents. The dentist didn't even want to go to a lawyer. So, and that's good and bad. It's always, it's as bad as it is good. It's good because someone's not coming in with a sharp pencil, but things can be missed. And again, under the parole evidence rule, you want to make sure everything's in the agreement. So look at it very carefully. If you're going into a small town type of arrangement and you get a cut and pasted agreement, put the agreement aside and make a list of what you want. Make a list of what is important to you. And then go down the page and check off and see what they have. And then Google it or call me or LECOM grads can email me and I'll give you language. But for the smaller town deals, your percentages might be good, your guarantees might be good, you're not going to have a lot of work rules, you're probably going to have a buy-in, but it's going to be a little loosey-goosey up front, and you got to know what you want and everything you want to have in that deal. I have been talking for 55 minutes nonstop, which means some of you might have an Eighth Amendment claim. That's a constitutional claim for cruel and unusual punishment. I would like, Danielle, if we could, just to see if there are any questions at this point.
Yes, there actually are quite a few already.
Let's go with questions, because I think that might have a better yield at this point.
Okay. So this, I think, goes back to near the beginning. Someone is asking if you can explain the independent contractor tax fraud again.
All right. Just say it's a few years from now, and you have developed new and creative ways to manage a dental practice, and you go from practice to practice and you sell your methodology. You could be an independent contractor. You would work at each practice for a short period of time. You would not be economically dependent on any one practice. They would pay you a set fee, and you would be on your way. If, however, you are economically dependent on one practice, if a single practice controls the details of your day-to-day work, as a matter of law, under the Internal Revenue Code, you must be classified as an employee, and taxes must be deducted from your compensation. You must be treated as an employee. In America, the default position is if you work for somebody else, you're their employee. There's a burden to show that you're somehow independent or in control so as to get outside of the typical tax withholding provisions and benefit entitlement provisions. If you sign up for an independent contractor agreement and you are not a true independent contractor, it is almost inevitable that you are evading taxes at the federal and probably at the state level as well. And these are crimes, so you want to avoid them. Ask yourself two questions. Am I in control? Am I economically independent? If the answer to those two questions is not a clear yes, then make sure it's an employment agreement.
Okay. The next question. Could you explain the difference between for cause and not for cause termination?
For cause means you lost your license, you came in impaired, you were impaired, you repeatedly drilled through someone's cheek. In other words, you were careless. There's a reason. For cause means there is a discernible, objective reason to get rid of you. Not for cause means your boss comes in one day and doesn't like the tie you're wearing, or just doesn't like your haircut, just doesn't like the tone of your voice, the sound of your voice, and says, look, I'm done with you. I can't stand to look at you anymore. You're out of here. Objective, discernible reason versus subjective desire to terminate.
Okay. Someone's asking, how do you suggest we find the right legal representation with the dental-specific employment contract experience in our state? Is there a resource that they could go to find a lawyer who would specialize in this?
I would start with the ADA. I think they have some referral sources. It's basically word of mouth. There is another search engine, but you really have to know how to use it. And I'm almost hesitant to tell you, but I will. It's called AVO, A, capital V, O, Albert, Victor, Victor, Oscar. And you could put employment agreement in, but you don't know if, and that will give you competent attorneys who do, say, employment agreements, but you don't know if they ever did a dental employment agreement. It's basically find someone older than you and say, who have you used? It's largely, I hate to tell you, it's word of mouth. Or, email Jennifer. Jennifer will email me, and I'll get you a name. But, I mean, I don't mean to be flip, ladies and gentlemen, but it's, there is no, picking a lawyer is very much like picking a dentist. There's a comfort level. You want someone who's actually been there and done that. But there is no, directory that I know of that says, lawyers who do dental contracts. Although I would go on the ADA website.
Okay. What is the best way to combat a contract with non-compliance?
With non-competes or?
It says non-compliance. What is the best way to combat a contract with non-compliance?
Well, okay, I'm going to take that question at face value and construe it literally. If the employer is not complying with provisions that it promised you, you need to give them prompt notice. And that's where the notice provision comes into play. Typically, it has to be in writing. At law, we often say if there's no writing, it never happened, or it could be taken as never happening. You got to be on the record promptly and advising the employer that you expect to have your contractual provisions honored. Now, the problem is it really comes down to bargaining power, because the employer can call you and say, "Oh, I got your letter, and you're saying I'm not doing everything I promised to do, that's true, but if you don't like it, leave. What are you going to do? It really comes down to clear. Always, whenever, people always say to me, well, so-and-so owes me money, what do I do? You write a demand letter. You tell them what you think you have a right to, what you're not getting, what you want, and see if you can negotiate it the best you can. Now, if the question was going to non-compete agreements, just try to limit it in time, geography, or blow it out altogether if you can.
Okay. Is it a must that professional expenses and licensure be covered?
No. No. There are no musts. There are no musts. There's one must. There's one must. You have a right to be paid for your work. You have a right to be paid for your work. That's the only must.
Okay. This is a good one. So it says, do employees get paid by productions of their work regardless of whether the patient insurance actually pays or not, or does the employee only get paid when the employer gets paid?
That depends. That's a matter of contract. That's a matter of contract. You're going in, look, there's something called the Fair Labor Standards Act, right? Which has 5 basic provisions: minimum wage, overtime, employment records, no employment or limited employment of children, and the I-9 provision, which means you have to prove that you're legally able to work in the United States. Dentists are exempt or exempted from minimum wage and overtime. Now, no one in their right mind is going to go to work for free. So there's going to be some term of compensation. You have a right to be compensated for all work. That's the one given. That's the one immutable. But yes, the actual payment can be deferred until the insurance comes through, or it could be reduced. It could be reduced based on excessive use of supplies or patient complaint. You need to spell it out very clearly. You need to spell it out as clearly as you can. And this is why a lot of times for young dentists, you have to draw. Okay, I'm going to pay you $2,000 a week, guaranteed. Well, not guaranteed. I'm going to pay you $2,000 a week against a draw, which is tied into a percentage of what you produce, less returns or delays.
Okay.
And ask for examples. Ask for examples.
You had talked earlier that the non-compete is not valid in California. So this question is, what if I agree to non-competition in California and they take legal action against me? Can they continue to take me to court?
They'll lose. Then you want to have an attorney fee provision because you'll get your attorney's fees.
Okay. What's a typical good production percentage bonus to ask for?
80. You'll never get it. I mean, I told you the market rates that I'm seeing are mid-20s to low 30s, or high 20s to mid-30s. Ask for as much as you can. But you go into a well-established practice, you're going to have a number. And the number you might see in corporate might actually be a couple ticks higher. But it's a percentage of what? If you're dealing with commodity work or managed care work or Medicaid work, it could be 50%, but you're not going to make any money. You want to go, ideally, you want to go to a practice with a 27% rate, with a healthy book of patients who are predominantly fee-for-service is going to be your best yield.
Someone's asking if you can explain indemnification again.
Indemnification means who pays if something goes wrong. If someone else sues, who pays? If liability is visited on either party, by the government, by a patient, by a vendor, who pays? You want to be indemnified, you do not want to indemnify. And indemnification has different levels. I mean, you can be indemnified so that they pay your damages. You can also be indemnified that not only do they pay your damages, but you provide a defense. So attorney's fees can also be in the picture. But you want to be the one getting indemnified. Indemnified is like insurance. Who pays? Who pays if something goes wrong? And how much do they pay, and what do they pay?
The next question is, what are the advantages of not phasing out the dentist you were buying out as opposed to phasing him or her out over time? You seemed in favor of getting them out as quickly as possible, but are there any advantages of not phasing them out?
Patient relations, maybe goodwill, maybe training you. But remember, at the end of the day, no one is primarily motivated by altruism. At some point, they're going to be looking around to benefit themselves. I think you want a minimum period of transition. You certainly want a process by which patients are introduced to you. And you definitely, regardless of how long you keep them in-house, make sure they have a restrictive covenant when they go out the door. Don't do a deal without it. That's a mandate.
There's a couple questions about liability insurance. So one person's asking, what are the provisions of liability insurance you should look for? And another person's asking if the corporate contract or the corporate companies usually pay for liability insurance.
Yes, that's an easy one. Yeah, the corporate companies will pay for liability insurance. When you set up a practice, you're going to have and the ADA does have on their website insurance advice and references to insurance brokers. Just say you're real aggressive and very entrepreneurial and you want to set up your own practice. Well, what are you going to need? You're going to need your own personal insurance and you're going to need practice insurance. You would have personal malpractice insurance and practice malpractice insurance. You're also going to have general liability insurance. What does general liability insurance cover? General liability insurance covers a slip and fall, coming into your practice. If someone, slips on the steps and, splits their skull open, on the concrete riser leading into your office. You're going to want to have, if you form a corporation, you're going to want to have D&O insurance, directors and officers insurance. If you grow rapidly and establish your own employee benefit plans, you're going to want to have fiduciary insurance. Every state will mandate that you have, if you have employees, workers' compensation and unemployment compensation insurance. Basically, you cannot operate a business in the United States without at least 8 to 10 forms of insurance. And for a healthcare professional, you have the malpractice added in. By the way, one other point on insurance. The number one target for identity theft are healthcare providers because there's so much information about you out there and everyone assumes you're rich. So you might want to have an identity theft rider, either on your homeowners or in your practice insurance.
Next question is, what is the best way to determine our own bargaining power and what's the best way to approach this? Since most might be going into this, right out of dental school.
Where'd you go to school? What's your skill level? Have you had a residency? Do you have patience? I mean, patience is the coin of the realm. You say, hey, I have 50 people lined up for me to be their dentist. Boom, you have bargaining power. There's no formula. There's no formula. It's how valuable are you? How valuable? What value do you add to that practice the day you walk in the door? For someone just coming out of dental school, might be a great person with good skills, upward trajectory, but you really don't have much. It's really when you get into your second job is when you get the bargaining power, where you're established, where people will follow you, where you've done so many procedures you can do it in your sleep, where you're efficient, where you don't waste time.
Okay.
And Danielle, before we move on to the next question, can I chime in on this one?
Sure.
I know of classmates who have been asked the number of procedures they've done. And so this is something you could keep track of as you are doing your 4th and 3rd year, and as you're getting more proficient in your treatments, you can say, I did 25 crowns throughout my life as a student, or I've averaged X amount of time per X amount of procedure. So you can keep track of all those things and bring them to the negotiation phase that Mr. Myers discussed.
I would agree with that.
Absolutely. Someone's asking, so how does the right to work law impact the covenant for termination?
Right to work has nothing to do with it. Right to work, the right to work law means that it has no applicability. The right to work doctrine has no applicability to anything we're talking about. It has to do with union membership.
Okay. Another question kind of.
Whoever raised the question, just put it out of your mind. Someone sent you down the wrong aisle.
We have another question related to termination. So how much termination notice time period should be usually there? I saw a contract with a 14-day notice, and I find that a very short time.
That's very short. That's very short. I mean, if it's less than 60 days, I mean, it's like, I just saw one, which was, I liked it a lot. I mean, they basically gave the new dentist, it's like, unless you do a major screw up, you're on for 9 months, and then 60 days are after. I kind of like that one. 14 days, that's insulting. I mean, seriously. I mean, you're a professional. I mean, you're not being treated professionally at that point. I mean, no less than 60 days.
Okay. So this is, I guess, a little bit more of a personal question, but this person is going to be buying a practice with another established dentist, and the other dentist is not giving this individual any say in the contract, but is asking him to pay half the lawyer.
Walk away. Walk away. Rule number 3. We covered that.
At what point do the fiduciary duties and the financial duties to a patient conflict with each other, and how can you resolve that conflict?
Repeat that.
So it says, at what point do the fiduciary duties and the financial duties to a patient conflict with each other, and how can you resolve that conflict?
I'm not sure I understand the question. When you taking a patient on, first of all, none of you are bus drivers. You don't have to take anyone who walks in the door. But once there's an offer and acceptance, once someone comes in and says, you know, I have a bicuspid, you know, the size of a walnut, and it's causing me a lot of pain, and you say, I can take care of that for you, show me your insurance, and you start working, that person is now your patient. You have to see that person through to the best of your ability. You cannot terminate that patient while they're in extremis. You have to hang in there. You might have to wait to get paid. You might have to sue them at the end of the day. But your fiduciary or professional care obligation does trump financial. Once you agree to take somebody on, the professional aspect is in the fore. I hope I answered that question. I mean, you have a right to get paid, but you can't stop a procedure midway through and say, "Hey, fork up some money." No, it doesn't work that way.
If the agreement states that there will be termination if the operation of the office is disrupted or rendered infeasible due to an act of God or changed circumstances, what should be done? Do you need me to repeat that, or?
Well, that's what we call it's called a force majeure provision, FORCE-MAJURE. If that is raised, I mean, you got to take cognizance. On a perfect day, you take cognizance of everything. So if you despite all of my advice, decide to set up practice within 5 miles of the San Andreas Fault in California, you might want to have insurance to cover that. Because there have been incidents that disrupt the practice beyond anyone's control. And typically, each person is left to their own devices and left to their own insurance at that point. No one's responsible. No one's responsible for an earthquake. No one's responsible for an act of God. So it's just make sure you got the insurance you need for any foreseeable negative occurrence or outcome.
Someone's asking, what is the IP covenant again? If you could explain that again.
IP covenant merely states that you might be subjected to restrictions on the use or ownership of intellectual property, discoveries or developments that you brought to the fore while employed at a practice. That needs to be clarified.
Do you have an idea of a cost for someone to have a lawyer look at a practice purchase agreement, just based on like how many hours you think it might take, or?
Well, depends where you are. I mean, if you're in Buffalo, New York, it's going to be a whole hell of a lot cheaper than if you're in New York City. When I left private practice in 2010, I billed at $600 an hour, and I was very good. But I could break down a contract in an hour. So, to get it done right, say plan on $1,000, at least $1,000.
Okay, that's a good estimate, at least for.
Yeah, I mean, in New York City, double it. In LA, double it. LA and New York are crazy, though. We all know
that. So next question is, if we need to undergo an examination for a blood-borne disease and medications, or we face any injury during the operating hours, who's responsible, and should something be included in the contract about this situation?
Typically, the practice would be obligated because, as I alluded to earlier, every practice is required by law to have workers' comp insurance, and that is a non-delegable, non-transferable duty. If you become injured or ill as part of your work, your employer is obligated to have insurance in place to cover you.
So we're down to just one last question, but before we do, I've had a few people ask me if this presentation and your sample contracts would be available. Just so everyone knows. Okay, so we have recorded this presentation, so it will be posted on ASDA's website, and then I can also post the presentation and the sample contracts at the same time.
Just do so. Kindly do so with a disclaimer that this is not specific legal advice. This is for educational purposes only.
Sure,
while
absolutely.
I would very much like meeting all of you in person, I am not the attorney to any of you. Just trying to help you out here. So it's not formal legal advice. I stand by everything I said, but it's too much of it's hypothetical. But from an academic standpoint and just a straight-up fact standpoint, I stand by everything I said. And please feel free to share it.
Great. So our last question is, so this person's saying, how does someone get a 20-month contract and a 60-day termination mixed up, and why do contracts even bring up the 24 months? I guess...
that's a great question. That's a great question, to which, the basic thing is, again, it comes down to bargaining power. It's like LeBron James, right? LeBron James has a 10-year contract, and it's all guaranteed, all right? His notice period is 10 years. It's nice to say, okay, we're going to be together 2 years, and this is how we're going to operate over the next 2 years. However, If I change my mind, I want to be able to change my mind with 60 days notice. It's bargaining power. The 2 years, the initial term, indicates how long the basic terms are going to remain in place absent an amendment. In other words, if everything goes good, this is how we're going to operate for the next 2 or 3 years. However, I reserve the right to change my mind, and if I do so, you're only going to get 60 days notice. That's what that is.
Okay. Well, that brings us to the end of our questions. So I did put up a slide that has our contact information. As I mentioned, this was recorded, so the full presentation or the full recording plus the presentation will be posted on our website. Mr. Myers, thank you so much for the very valuable information. I can tell by the questions that that everyone got a lot out of it. So I want to thank everyone for joining us tonight, and this brings us to the end of the program.
Thank you very much.
So thank you.